he's an expert in his field, but I'm not offering him for that purpose. I'm offering him as a witness, as a doctor at the prison who has treated this individual. If I were offering him as an expert, I would ask him to, I'd have to qualify him, which I'm sure he's qualified to do, and he could talk to the jury about the diagnosis that he has from my client and how he arrived at that diagnosis and what those diagnoses causes a person to do, and then that would be something that perhaps a jury would consider. And if that were the case, I wouldn't be calling Dr. Hammer, because he has a conflict of interest in the sense that he works for the state and he's not here for that purpose. We would hire our own psychiatrist to evaluate and testify to that effect. We gave notice specifically, well in advance of this trial, that we were not going to do that. I'm not calling Dr. Hammer to do those things. I'm only asking him, as a doctor working for the state, to testify as a fact witness as to what he has done with Mr. Broyhill. And the state of mind, a person's ability to weigh consequences, is an argument that we're allowed to make to the jury. And aside from the fact of whether or not we have many issues for the jury to consider regarding Mr. Broyhill's actions in this event, and in that argument, we need to be able to talk about the fact that not just that he never articulated a reason for doing these things, but an explanation from our standpoint, and we've said it from the beginning, that this was about a suicide. Mr. Broyhill cut himself. Mr. Broyhill, that's physical evidence, that's direct evidence we know from witnesses who have testified in this case. It hardly counts as anything else. We're going to be able to talk to a jury about whether or not, from those facts, that the intent of Mr. Broyhill on that day was to do harm to the Hans, or whether the intent was to do harm to himself. We have physical evidence to support that, and we can make that argument. But the weighing of consequences, the thought process that goes into that, goes to the issue of premeditation. And we should be allowed to tell the jury that this individual, Mr. Broyhill, from the time that this event has occurred, has been held as a safekeeper, which means that he's been a threat to himself. And there's been testimony about that, because they said they put it in for himself. And all this does is explain why. That's all. If he were an expert witness, we'd be asking for much more of this witness, and you know that. Because he would get to, after qualifying him, he would get to talk to the jury about the length of his diagnosis and his thoughts and why he went into it, and he'd be rendering a forensic opinion. That's what expert testimony is about. There's not one question I haven't asked that isn't solely directed to what he has done, not as a forensic expert, but as a treating physician for this client who was his patient. That's all we're calling, and that's all we're asking to do, and I'm not going to ask a different question from the ones that I asked.
Of the questions you're asking, let's look at a few of them. Experts are permitted, because of their knowledge, skill, experience, or training, or education, to testify in the form of an opinion. And that's what separates experts from lay witnesses or fact witnesses. So, honing in on a couple of your questions, you ask.
I don't mean to interrupt you. Can I just speak to that one thing that you just said? I don't know how that would be any different from a homicide detective who just gave testimony about all the tactics and things that he's learned on how to do a statement, how to preserve a crime scene. There's no difference. If they're allowed to talk about the nature of their job and what they do, he's no different. I'm not offering him as an expert witness, and I object to the court referring to him as an expert witness. He's a fact witness.
Well, and that's the distinction that the court has to draw, is whether this is an expert for which you would have been required to provide, among other things, a curriculum vitae and a report to the state as part of the reciprocal discovery obligations in advance of this trial. And so the question is whether this is a fact witness or whether this is an expert. I'm not calling him anything at the moment. I'm just simply saying that the definition of an expert witness is that which is set out in Rule 702. And so that's the rule of evidence that we're referring to here. Then I want to hone in on a few of your questions here and just talk about whether they constitute a call for an opinion that would be within the scope of Rule 702. So, do you prescribe medications for inmates if you believe it will help mental condition? Then, several questions later, you said, did you prescribe medications to Mr. Broyhill for mental issues? And so the answer to the first question was yes. Answer to the second question was yes. And then he lists the 4 medications that he prescribed, and that they were prescribed for anxiety, psychosis, and depression. So let me hear from you, Mr. Arbor. You're listing from this witness that he formed an opinion that he believed it would help Mr. Broyhill's mental condition, and he believed that those mental conditions were anxiety, psychosis, and depression, and he prescribed 4 medications which he believed would help with those conditions. And tell me why that is not an expert opinion from a medically trained individual.
Expert opinion goes to the why of why a person did something or an explanation. I'm not asking him to do that. I'm asking him to testify about what he did for treatment purposes. No one's asking him any questions in the questions I asked about why you're giving him the medications. I asked him, did you give medications? Is this what it's for?
Well, you
I'm
said,
not asking him to explain it.
You said if you believe it will help his mental condition. I mean, obviously he gave it to him because he formed the opinion that it would help his mental condition, and then he described the mental condition as being anxiety, psychosis, and depression. And so is that not an answer to why?
No, not to why he did the behavior. That's what a forensic opinion is about. A forensic expert is here to testify why an individual did something. I'm not asking him to testify about why Mr. Broyhill did these things. If the question is why he gave him the medication, the answer is because he suffers from those things and he's giving them medication for those things, but it doesn't go to why he did these events. That's all. I never once asked him a question about why Mr. Broyhill did these events.
Well,
he's not rendering an opinion about that. He is not an expert witness as it pertains to a forensic psychiatric expert under the rules of 905.
Well, an expert's
15A905.
I mean, an expert who's talking about, say, DNA evidence isn't testifying as to why someone did someone. They're only rendering expertise in their field of specialization that says, in my scientific opinion, this sample is consistent with the DNA taken from a suspect. And it doesn't go to the why, but it just simply is, I've got specialized training in evaluating samples, and I conclude based on my training that this is the scientific result based on the tests I've run. And so here we have an expert or a psychiatrist who's saying, I formed a belief based on review of records or whatever else he did, that this person suffers from anxiety, psychosis, depression, that medication would help those conditions, and therefore I prescribe the following medications. And I'm having difficulty separating that from any other expert who takes a stand.
702 says, if specialized knowledge will assist the trier of fact to understand the evidence or determine a fact in issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if all of the following apply. I'm not asking him for an opinion. I'm not asking him to give an opinion as to why Mr. Broyhill did any of this. I'm asking him, did you prescribe medication and what it is? That's it. I'm not asking him to render an opinion as to why Mr. Broyhill did these things. To deny him this denies Mr. Broyhill an opportunity to explain information that the state has put in, because the state has raised a big issue regarding credibility in this case. The state has been allowed to put one of three statements in of this defendant. And we've made our objection with respect to that, but on that statement, Mr. Broyhill says that he'd been suffering from depression. There's information in there that suggests he's been feeling anxious and that he had been suicidal. This evidence is offered, and we know that he was suicidal because we have physical evidence of that. And this evidence is being offered to demonstrate that Mr. Broyhill was being forthcoming in his discussion with the officers on the 26th of April. Because this corroborates that he was feeling those things. It's not offered as an explanation for why he did those things. It's not an expert opinion as to what the whatever illnesses he has would cause someone to do. I'm not asking any of those questions. It only goes to that issue. And all these other things about stealing money and about everything else, the state is allowed to go in and corroborate it with the investigative work done by the police department to show, well, this is what was true, this is what was not was true. They take a portion of a statement and put it in. Well, we should be able to offer this evidence to show to the jury that he wasn't making that up. And that's all it is. Otherwise, you allow them to stand up there and let the jury's mind run wild that all of his stuff that he says, because we do have, there's admitted credibility issues. We've admitted them. We've admitted it with almost every witness that's come in. So to not permit this evidence is to deny Mr. Broyhill an opportunity for us to be able to stand up on his behalf and say that when he was talking to Detective Morse on April 26th, and he said he was feeling depression, and he was feeling anxious, and he was feeling suicidal, it just goes to show that he was being forthcoming that day. And it allows us to talk about that. Because one of the things they have to do, engaging whether or not he committed a crime, is decide what they want to believe and what they don't want to believe. And by denying him an opportunity to offer this evidence to the jury, what you do is you handcuff us. You prevent us from being able to say to the jury, listen, when he was saying that to the detective, that he was feeling these things, he wasn't lying. He was telling the truth. And for those reasons, we offer this testimony. This is not an expert witness. It's to corroborate a very important piece of Mr. Broyhill's statement, which has been offered against him. And to deny him this would be to deny him a right to a fair trial and also deny him a right to for us to properly confront the witnesses against him. It would be a violation of the Confrontation Clause.
Well, the problem I'm having is that if there is a grounds to deny it, the first threshold has to be overcome is why isn't there been an exchange of information with the state? Because I mean, that's a decision that you made, and you made it perhaps based on a calculation that this is not an expert.
No.
All right. What's the basis for that?
15A905C says that I'm only required to give notice if I'm going to give notice of diminished capacity, or NGRI. I specifically have stood in this court prior to this and indicated that we are not putting that notice on. If I were doing diminished capacity, I would then have a forensic opinion that I'd be able to stand up and say to the jury as an affirmative defense that if they believe the defense witnesses that there was a diminished, that the defendant was acting pursuant to diminished capacity, they can then consider murder in the second degree.
Well, what about?
I'm not asking that.
Sir?
I'm not going to be
Okay.
arguing that.
You're on the different statute. What about 15A-905 B, C2, to give notice to the state of any expert witnesses the defendant reasonably expects to call as a witness at the trial?
That falls under C. You only do it if you're going to give notice of the diminished capacity of the NGRI. They're not mutually exclusive. It all comes under subdivision C.
Mr. Fawcett, what's your position with respect to whether the notice of experts is only required if a notice of defense is given?
Judge, the 15A-905, starting with B, if the court grants any relief by the defendant, that's the reciprocal discovery, the court must, upon motion of the state's done that, order the defendant to permit the state to inspect and copy results, reports of physical and mental examinations. We know there are apparently medical records at both Craven and Central that's been relied on or created by this doctor.
I haven't brought any here.
The state of North Carolina doesn't, this prosecutor's office doesn't have those, Your Honor. Within the possession and control of the defendant, which the defendant intends to introduce in evidence at trial, or which were prepared by a witness whom the defendant intends to call at the trial when the result to reports relate to his testimony. Judges, the state's position is this is clearly expert opinion being proffered through this witness. And as to that, and if you want to call it a fact witness, it's not relevant. It has to do with post-defense date conduct, even under diminished capacity, which this is what this type of evidence is, whether you can plan or think, whatever you want to call it, whether it's diminished capacity, mental infirmity, whatever word in this discovery statute there is. That all has to relate to the offense date, even if you do this properly. This has nothing to do relevant-wise, and any 401 is well outweighed by 403.
So,
If I can be heard on that, 15A-905B does not apply. We're not offering any examinations. We're not offering any tests. And with respect, I don't even know how to reply to the 403 argument, because quite honestly, a person can have mental health issues, and if they weren't seeing a doctor at the time, there aren't going to be any records. And if they're being seen by a doctor after the event, and it indicates that the person has been prescribed a medication for the things that the defendant was talking about when he talked to the police officer while he was in the hospital, that corroborates that he's not lying. I'm not offering an examination. I'm not offering a test. I'm not offering him to give an opinion. I'm asking him, as a licensed physician in this state, what did you do with this patient? What did you prescribe? It goes to the statement. It goes to the facts. It doesn't go to an opinion. We were under no obligation to provide any notice. We were under no obligation to provide him with any records. If I had asked Dr. Hammer to prepare a test, if I had asked him to prepare a report, I would have given it to Mr. Foster. I didn't ask that question of Dr. Hammer, but I didn't ask him to prepare a report, or did I?
No, sir.
Thank you.
Judge, again, the state's position is this is expert testimony. When you get to have a doctor talking about prescribing medications for anxiety, depression, psychosis, which is a medical judgment and a treatment, his opinion, would you prescribe medicines if not needed? That would be unprofessional. I wouldn't do that. I mean, that's what this is. This is expert testimony with no reciprocal discovery. And as far as, and also a 403 argument, Your Honor.
Mr. Arbor, you acknowledge that that there was voluntary discovery in this case provided by the state under 15A-902A. Is that correct?
I'm sorry, say it again.
You acknowledge that there was voluntary discovery by the state pursuant to 15A-902A, is that correct?
Well, I'll acknowledge it. I will also state on the record that there was dates put on them to provide us discovery with by a certain time. There was a declaration by the state that they gave us that, but subsequent to that date, I will respectfully submit that we received thousands of pages after that. I'm sure that was information that came to Mr. Fawcett after he had said to the court that he had complied with what he had at that time. But it left us with, I mean, we've been getting evidence right up into the time of trial. So but we filed a request for voluntary discovery, and he gave it to us in that fashion.
All right. And then we've got an order from Judge Stevens that was entered April 17, 2014 that says reciprocal discovery due same date. That looks like May the 30th was that date. That was also the date for defenses. And then that may have been moved back. There's several orders relating to that date.
Mr. Broyhill wasn't even a patient of Dr. Hammer on May 30th.
All right. So then I think there's one that says on June 25th, 2014, it says defendants should be given until August 14th to file defenses in this matter, comply with reciprocal discovery regarding expert witnesses.
We filed no motion under diminished capacity or NGR. I've already put that on the record.
Right.
Not tendering Dr. Hammer as an expert witness as a forensic expert.
Right. And then, of course, 15A-905D says if the defendant provides voluntary discovery, disclosure shall be to the same extent as required by subsection C of this section. So we go back to section C, and section C requires three things: notices of defenses, which you've acknowledged you have not provided any,
correct,
including a diminished capacity or not guilty by reason of insanity.
Correct.
It requires give notice to the state of any expert witnesses the defendant reasonably expects to call. You've not given any notices of expert witnesses.
Not offering him as an expert witness.
All right. And then the third is give the state at the beginning of jury selection a written list of names of all other witnesses whom the defendant reasonably expects to call during trial. So
his name was on the list.
Right, and you have complied with that. So
yes.
You've complied with
all three of those subdivisions.
All right. So really it does come down to a question as to whether this testimony falls within the scope of the testimony of an expert or whether it is not expert testimony. That is the ultimate question for the court, because if it is expert testimony, then you have not given notice of that to the state, and for that reason, statutory reason, as well as Rule 403, that it would not be permitted. If it is not expert testimony and it's just a fact witness, then you've given notice on your witness list that you gave prior to jury selection that this individual is going to testify.
Correct.
All right. So that's what the issue comes down to.
Well, respectfully, that's not just the issue, Judge. We jump ahead often and we forget about 401. Relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence.
Right. And 403 starts, despite the fact that evidence may be relevant, it may be excluded for the following reasons. So
right, but Your Honor has to determine first whether or not it's relevant. And Mr. Fawcett respectfully has stood up and said it's not relevant. And quite honestly, I don't know how it cannot be relevant when he's offering my client's statement where he's saying that my client is saying he's depressed, where he's saying he's anxious, where he's saying that he's, suicidal and been thinking about taking his life for some time. And we know for a fact that he did try to take his life on that day. And that's something that the jury can reasonably conclude from the evidence. And so this evidence is in support of that. So it is relevant. And to suggest that it's not, quite honestly, is out of line for the state to say such a thing.
All right. Well, that may be an issue of interest to you, but it's not an issue I'm focusing on. I'm focusing on 403, and I'm focusing on, I mean, you've argued that the court will be preventing you from offering a defense or corroborative evidence of credibility and state of mind, or not state of mind, but, well, state of mind, yes. And the first issue is that the statutes provide a mechanism for doing that. And so you've chosen not to submit any information pursuant to 15A-905C2, which would give the state notice of any expert witnesses. And you have, and you're basing that on an argument that this testimony is that of a fact witness and not an expert.
That is correct.
All right. And you intend to ask him
Exactly the same questions.
Right. I'm going to go down the list and let's think about these questions to help me determine whether this is a expert witness or a fact witness. So the first one that I've already discussed is...
Where are you at, Judge?
This is early in your questioning. I don't have a transcript. I'm reading from my notes. You asked, do you prescribe medication for inmates if you believe it will help with their mental condition? And then 3 questions later, you asked, did you prescribe medications to Mr. Broyhill to deal with his mental issues? And then you asked what he believed those mental issues were, and you asked what medication...
No, I did. Excuse me, respectfully. I didn't ask him that.
All right. You asked him what the medications were prescribed for.
Right, because they're in compliance with the evidence in States 84.
All right. And he responded that he prescribed 4 medications for anxiety, psychosis, and depression. The next question, you asked him whether he makes his own evaluation to determine whether a patient is in need of those medications. So, and he responded affirmatively he did. He does conduct that evaluation. You asked him whether he has reviewed summaries and charts from other treating facilities, and he indicated he had. He indicated he made a determination that Mr. Broyhill would remain on the same medications that he received prior to his transfer. And that he has continued on those medications until now. He indicated that he would not prescribe these medications if he did not believe they were needed. He would not prescribe them just because he was asked for those medications, and he would only prescribe them if there was a legitimate medical need. I'm having trouble, Mr. Arbor, distinguishing between this testimony and that of a medical expert who comes in and gives a diagnosis and a treatment plan for any patient based on an evaluation or review of records. I mean, isn't that what this is?
No, not at all. It's not even close. I mean, Your Honor, I assume, has done trials and hearings where an expert witness has testified. That they talk about what the diagnosis is. They talk about what the diagnosis does. When someone has a mental health issue, they talk about what the mental health issue is, what it causes people to do. They get to give an opinion as to whether or not the behavior in this particular event is consistent with someone having that mental health disease. I'm not asking any of those questions. That's what an expert does when you're asking to go for diminished capacity or NGRI. We're not asking you. Those questions aren't there. Those questions are just the issues that were raised in State's Exhibit 84, based upon the statements that my client made, are only to corroborate that he wasn't lying. He wasn't lying to the police officers. The fact that they were given afterwards just demonstrates he didn't have medical care until after this happened. If he were lying, they wouldn't be giving him the medication. That's the argument we can make. Credibility is a huge issue in this case. We've got a defendant who has stolen money, lied on FEC reports, lied about having mental health illnesses that aren't real, that has attempted suicide. We need to be able to talk about this. Otherwise, you just let the state have everything they want to have and present one case. This isn't their trial. This is the defendant's trial. This is his opportunity to stand up in front of a jury and say, I didn't premeditate and deliberately kill this woman or attack her husband. And if he doesn't get an opportunity to present any evidence to demonstrate what kind of condition he was in on the time that it happened, and I'm not asking them to go find diminished capacity, all I'm asking is for them to be able to consider that when he talked with the officer on the 26th, he's being forthcoming. When he's saying these things to Detective Morse, he's not lying. If he were lying, this gentleman wouldn't be giving him medication for those issues. But if you don't allow it in, then what happens is Mr. Fawcett's in a position to stand up in front of the jury and say, how do we know what he's telling the truth about? He lies about this, he lies about that. So he could be lying about whether he's depressed. He could be making, in fact, I assume he's going to stand up and make all kinds of stories. That's what the whole presentation has been. That this is some intentional act. That this was some thing to get away with stealing money and running out of town. I mean, that's what the presentation was. And if I can't present something to counter that, if I can't raise a defense on behalf of my client, offering the jury an alternative explanation to what the state is offering, then you're denying him the right to have his fair trial in front of this jury.
But that's the point you keep going back to. The point.
That's the whole thing.
Well, no, sir. The point is that there is a process by which exactly that sort of evidence comes before a jury.
And I was very careful to examine the rule and respectfully, look, you've been ruling against me through the trial.
No, sir, I've been ruling consistent with the law. I've not been ruling against you.
I'll respectfully disagree with that. But my point is this. He's entitled to have an opportunity to present a defense. His lawyers have an opportunity to use the law. He is not an expert, as the law recognizes an expert giving an opinion. If we are not tendering him as an expert, you're asking me now to comply with regulations that apply to a forensic expert when we're not tendering him for that purpose. He is solely a fact witness. And now you're trying to place regulations upon us as to how to marshal in relevant evidence that don't apply to what we're asking him to be used for. If he were an expert, I agree with you. Him to talk about Mr. Broyhill's diagnosis, him to testify about what that diagnosis is to do, we'd be having a different discussion. And then I would be wrong not to have provided Mr. Fawcett a report or an opinion and his curriculum vitae. But I'm not asking Dr. Hammer that. I'm asking Dr. Hammer, are you a doctor? How are you employed? Was he your patient? Did you give him medication? What was that medication? And a couple of questions about what a safekeeper is and about whether he would give medication to him if he didn't, simply because he asked it. That's all I'm asking.
All right. Well, what we're going to do is we're not going to call this witness today. I'm going to continue to take this matter under advisement, and we will, if he's allowed to testify, it'll be tomorrow.
I just would ask, because I had told Dr. Hammer that we would use him today. I know he has patients at other facilities that he treats. I'll ask you to just instruct him that this is not our
Yeah,
doing the court.
I think that's clear. Doctor, you recognize you're under subpoena, and if we need you tomorrow, then you're required to be here. Do you understand that, sir?
Do you want me tomorrow or not?
I don't know yet, sir.
When would I know, sir? Because I have clinic, I have to set things up.
I understand. I'll need an opportunity to review this matter carefully and.
No problem, sir. Just,
All right.
when should I expect? Sir?
I'm not going to put I don't know what's coming on the remainder of the day, and so I'm not going to put a time limit on the court. So you need to expect to be here tomorrow morning unless you're told otherwise.
So if I don't get any calls, then I will be here at what time?
I imagine your attorney will communicate, not your attorney. I'm sorry. I imagine that Mr. Arbor, the attorney who subpoenaed you, will contact you.
All right. All right.
All right. Thank you, sir.
All right.
All right. So we will proceed with any other witnesses that you have available today. Are there any other matters that we need to take up? All right, very good. Then let's bring jurors in.
Can I use the restroom?
Yes, sir.
Or were you planning a break soon?
I was not planning a break soon, but we can take a 5-minute break right now, and then so we'll be in recess for 5 minutes.
Superior Court stands in recess for 5 minutes.